The moment a cop leans down to your window and says, "Step out of the vehicle for a second," most drivers reach for the door handle without thinking. That one reflex, that one automatic response, is exactly what officers are trained to get from you, because the second your foot hits the pavement, the entire legal landscape of that stop shifts, and it shifts in their favor. This is tactical education only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Here's what happens when you comply without thinking. You just abandoned the strongest legal protection you had. Your vehicle is your private space. Courts treat it almost like an extension of your home. But the moment you step out voluntarily without asking a single question, you've handed that protection over without the officer having to earn it. Body cam footage shows this pattern over and over. Driver steps out, officer moves to the window. Search begins within 90 seconds. Through tactical analysis of hundreds of recorded traffic stop encounters, I've identified exactly what separates drivers who walk away in control from drivers who give up far more than they had to. The difference is not attitude, it is tactical knowledge deployed in the right sequence. I'm going to show you 6 counter moves that cover every scenario officers use around the exit command, from the soft request to the lawful order, from the unlawful stop to the post-exit search trap. These are the exact words to say, the exact sequence to follow, and the exact moment to deploy each one. Stay tactical, stay calm, stay in control. This is tactical education only. For specific legal advice, consult an attorney in your state. Counter move number 1. Identify whether it is a request or an order. This is the most important split-second decision of the entire stop, and almost no one makes it correctly. Officers are trained in communication techniques that blur the line between a request and a command. They do this deliberately. When an officer says, "Hey, can you step out for me?" or "Do me a favor and step out," that is a request. A request carries zero legal obligation. You can decline. Nothing escalates because they have not issued a lawful command. But when an officer says, "Step out of the vehicle," that is an order, and the law treats those two moments completely differently. Here's the real situation. You're pulled over on a Tuesday night. The officer returns 2 minutes later and says, "Hey, do you mind stepping out for me so we can talk?" Most drivers think this is a command. It is not. It is a request. And most drivers open that door within 3 seconds. The moment they do, they voluntarily stepped out, opened the vehicle to plain view observation, and made everything that follows look willing on camera. Your counter move is this. Say it calmly, say it clearly. "Officer, are you asking me or ordering me to step out?" That is the sentence. Practice it right now. "Officer, are you asking me or ordering me to step out?" Say it again. "Officer, are you asking me or ordering me to step out?" One more time, lock it in. "Officer, are you asking me or ordering me to step out?" Here's why this works tactically. It forces the officer to define the legal status on camera. If it was a request, they must acknowledge it. If an order, they must justify it. Either way, you've created a record and you are in control. The wrong move is automatic compliance. Body cam footage shows the pattern. Driver steps out. Officer says, "While you're out, mind if I take a look inside?" Driver says, "Sure." And a consensual search begins the driver never intended to allow. Your recording changes that outcome. Cameras document everything, and that footage is your tactical evidence. Tactical summary: never open that door until you know whether you're being asked or ordered. That one question resets the entire tactical landscape of the stop. Now you've established whether it was a request or an order. But if it is an order, most drivers think that's the end of the conversation. Wrong. An order does not mean a blank check. Counter move number 2 reveals the next layer of protection that almost no one knows to use. Counter move number 2: demand the lawful reason for the order. Under Pennsylvania versus Mims from 1977, officers can order a driver out of a stopped vehicle in the interest of officer safety. That ruling is real and settled, but here is the tactical intelligence most drivers never receive. Mims does not give officers unlimited authority. The stop itself must be lawful, the safety basis must be articulable, and the officer must be able to explain it. Here's what actually happens in the field. An officer issues an exit order. You now know it is an order, not a request. Your next move is calm, direct, and documented. You say, "For the record, What is the lawful reason for ordering me out of the vehicle? Say that with me right now. For the record, what is the lawful reason for ordering me out of the vehicle? Again, for the record, what is the lawful reason for ordering me out of the vehicle? Third time, own it. For the record, what is the lawful reason for ordering me out of the vehicle? Here's the live exchange. Officer, step out of the vehicle. You. Officer, are you ordering me to exit? Officer, yes, step out. You. For the record, what is the lawful reason for ordering me out of the vehicle? An officer acting within their authority gives a clear, specific answer. I can see something on your seat, or your movements were concerning. That answer documents the lawful basis on your recording. An officer who is fishing becomes vague. Because I told you to, or for my safety, with no specifics. That vagueness becomes evidence on your side. This move does not challenge the officer personally. It does not escalate anything physically. It turns on a bright light in a moment that most officers rely on staying dark. Cameras document everything, and your recording plus their body cam is your tactical advantage. The escalation path. If you skip this, you step out because they said so. You never establish whether the order had a legal basis, and anything found during the stop that follows looks perfectly lawful on paper because you never created a record of challenging the foundation. Tactical summary. An order is not automatically valid. 4 words. What is the lawful reason? Forces the justification onto the record before you move an inch. You've demanded the lawful reason for the exit order, but what if the stop itself was never lawful to begin with? This is countermove number 3, and it is the foundational protection that everything else rests on. Countermove number 3, challenge the validity of the stop itself. Here is the tactical intelligence that changes everything. Pennsylvania versus Mims is specifically conditioned on a valid traffic stop. The court's exact language says that during a valid traffic stop, an officer may require the driver to exit. Valid. That one word is your tactical entry point. If the stop had no lawful basis, if the officer pulled you over on a hunch or pretext without an actual violation, then Mims does not apply. They can't lawfully order you out of a vehicle they had no legal right to stop. Body cam footage and court records show stops where exit orders were later ruled unlawful because the original stop could not be justified. Here's the real situation. You're driving in a residential area. You haven't committed a traffic violation. An officer pulls you over. They approach and ask you to step out. Your countermove starts here. Officer, for the record, what traffic violation or specific articulable fact justified this stop? You are establishing on camera from the very beginning whether this officer had legal grounds before a single additional order is issued. The live exchange. Officer, license and registration. You hand over documents. Officer, step out of the vehicle for me. You. Officer, are you ordering me to exit? Officer, yes. You. Before I comply, for the record, what was the legal basis for the initial stop, and what is the lawful reason for the exit order? Why does this sequence matter? If the stop was unlawful, everything that follows, the exit, the pat-down, any search, may be challengeable. Your recording capturing the officer's inability to articulate a lawful basis becomes your most powerful courtroom asset. Stay calm, stay tactical, stay in control. Tactical summary. Mims only applies to valid stops. If the stop itself was shaky, put the officer on record about the basis before you move. Now you've challenged the validity of the stop and demanded the lawful reason for the exit order. But here's what body cam analysis reveals at this critical moment. Most drivers lose their tactical advantage in the 3 seconds before they open the door. Countermove number 4 covers exactly what to do in those 3 seconds. Countermove number 4, execute the pre-exit protection protocol before your hand touches the door handle. This is one of the most underestimated tactical moves in a traffic stop. The 3 seconds before you open the door decide your protection level for everything that follows. Most drivers rush, comply quickly, and abandon the most important setup available to them. Before you move, before you touch the handle, make one announcement, clearly and calmly. I am complying under your order, and my hands will stay visible the entire time. Say it. I am complying under your order, and my hands will stay visible. Again. I am complying under your order, and my hands will stay visible. Third time, on your recording. I am complying under your order and my hands will stay visible. Here's what this does tactically. First, it eliminates any claim that your compliance was voluntary. On your recording and on their body cam, you have stated clearly that you are following an order, not making a choice. This matters enormously if the order is later challenged as unlawful. Second, it removes any excuse for a safety concern about sudden movements. You have announced what your hands will do before you do it. Third, it creates a documented moment of transition. The officer's order on record, your compliance on record, your protest of that order on record. The wrong move. Door swings open, hands drop briefly. Officer claims a furtive movement, and now you're facing a pat-down that expands into a search based on a safety concern your recording could have prevented. Before you exit, state, "For everyone's safety, I'm recording this interaction as well." That footage is your tactical evidence. Tactical summary. The 3 seconds before your door opens are not wasted time. They are your most powerful recording window of the entire stop. You've executed the pre-exit protocol. Your compliance is on record. Now you're outside the vehicle. Here's what most drivers get catastrophically wrong at this exact moment. Counter move number 5 is the move that reestablishes your Fourth Amendment protection the instant your feet hit the ground. Counter move number 5, the exit and lock strategy. Turn your vehicle back into a fortress. The moment you step out of your car, the officer's goal shifts. They wanted you out for a reason. That reason is access. With you outside, they can approach the window, claim they smell something, claim they see something, claim a safety concern, and now they have a narrative to justify a search. Unless you execute this counter move the moment you exit. Here's the move. Before you shut the door, press the lock button. Step out. Close the door. Locked. Completely legal in every state. You have complied with the exit order, but you have reestablished a Fourth Amendment barrier between the officer and your vehicle. Here's the live exchange that follows. You've exited, closed, and locked the door. The officer's next move is almost scripted. Body cam footage shows this repeatedly. "Before I put you in my car, you don't have anything on you, right? Weapons, drugs. You mind if I check your pockets?" That is the roadside consent trap, designed to get you to say yes and open a chain of escalation toward the vehicle. Your counter move to the pocket question is immediate. "I do not consent to searches." Say it. "I do not consent to searches." Again, "I do not consent to searches." One more time, be a broken record. "I do not consent to searches." The officer can conduct a pat-down for weapons based on reasonable safety concerns, but they cannot reach into your pockets. They cannot access your locked vehicle, and they cannot search your car without your consent, a warrant, or probable cause, none of which locking the door creates. Tactical summary. Compliance with the exit order and protection of your vehicle are not mutually exclusive. Exit, close, lock. In that order every single time. You've exited, you've locked, and the officer is now trying to manufacture a pathway back into your car. Counter move number 6 covers the 3 ways they try to get back inside, and the tactical response to each one. Counter move number 6. Shut down the 3 post-exit access tactics. After you've locked your vehicle and refused pocket searches, officers have 3 remaining pathways into your car. These are deployed in sequence, escalating pressure with each attempt. Knowing all 3 and having your counter ready is what separates a prepared driver from one who gets searched without realizing they had options. Access Tactic 1. The smell claim. I smell marijuana coming from your vehicle. This is the most commonly deployed pathway in states where odor still constitutes probable cause. In states like Texas and Ohio, an officer claiming to smell marijuana is still their green light to search. But in states like Colorado, Illinois, and Maryland, odor alone no longer establishes probable cause since legalization. Your counter move regardless of state. Officer, I do not consent to searches. If you believe you have probable cause, I want to speak with an attorney before any search proceeds. Say that clearly and calmly. Do not argue about whether they smelled something. Do not explain. State your counter move and go silent. Access Tactic 2. The plain view claim. I can see something on the seat of your vehicle. Officers position themselves at your window and scan the interior. Items that look like paraphernalia or anything unusual can be described as justifying entry. Your counter move. Officer, for the record, I do not consent to searches. What specifically are you claiming to see? Your pre-exit announcement and recording are already running. Make them describe it specifically. Access Tactic 3, the drug dog extension. Under Rodriguez v. United States, 2015, officers cannot extend a traffic stop beyond its mission to wait for a drug dog without independent reasonable suspicion. Your countermove. Officer, has the traffic stop mission been completed? Am I free to leave? That question is your weapon against prolonged detention designed to manufacture a K-9 search. Stay calm, stay tactical, stay in control. Be polite, not talkative. Cooperation does not equal conversation. These are documented countermoves that forced the officer to justify every step of escalation on your recording and their body cam. Tactical summary: lock the door, refuse consent, and require specificity for every claim. Make them earn every inch of access legally. Now you know 6 countermoves covering the full arc of the exit command, but there is one scenario where refusing to exit is not a viable tactic. And understanding this moment is what keeps you from turning a legal encounter into a criminal charge. This section covers when you must comply and how to do it tactically, when the tactical choice ends, the moment you must exit, and how to do it right. There is a clear line every tactical driver must recognize. When an officer says, "You are being detained, step out of the vehicle now," those are not the same words as "Can you step out for me?" The word detained changes everything. It means the officer has articulable, reasonable suspicion. The exit order carries full legal force, and refusing creates new charges: obstruction, failure to obey a lawful order, resisting arrest. Depending on your state, any of these can follow, and judges will support the officer on safety grounds. Here is the mistake most people make. They think refusing to exit is fighting for their rights. At the point of a lawful detention order, refusal is fighting the wrong battle in the wrong arena. Your battle happens in court, not on the roadside. Your recording gets you there. Resistance on the roadside eliminates that option. Live exchange. Officer says, "You are being detained. Step out of the vehicle." You say, "Officer, am I being detained?" Officer, "Yes, step out now." Your response is not argument. Say, "I am complying under your order. My hands will remain visible." Execute the exit and lock strategy. You've complied. You've documented. You've preserved your vehicle's Fourth Amendment protection. What you never do: match their energy, argue on the roadside, make sudden movements, or refuse a clear lawful detention order. Assert your countermoves with calm precision, and you maintain tactical advantage. Get emotional, and you lose control of the encounter. Your physical protocol: once outside, maintain about arm's length from the officer, keep hands visible, announce every movement before you make it. "I am reaching to adjust my jacket," and keep your voice level, even while asserting rights in substance. Tactical summary: the roadside is not the courtroom. Comply with lawful detention orders, lock the vehicle, refuse searches, and let your recording carry your challenge to the judge. Here is the field rule that covers everything you just learned. Your vehicle is your strongest tactical asset during a traffic stop. Every countermove in this video exists to preserve that asset for as long as legally possible, and to document every step of how it was compromised if the officer takes it further. Let's lock in the 4 countermoves that cover every scenario from today's training. Countermove 1. Officer, are you asking me or ordering me to step out? Deploy this the instant any exit is requested. It forces classification of the interaction. Countermove 2. For the record, what is the lawful reason for ordering me out of the vehicle? Follow immediately if an order is confirmed. Puts the legal basis on your recording. Countermove 3. I'm complying under your order, and my hands will stay visible. Your pre-exit announcement locks in your protest and your safety on camera simultaneously. Counter move 4. I do not consent to searches. Post-exit broken record response to every access attempt. Pocket searches, vehicle searches, trunk searches. Say it every time. Right now, practice these 4 responses out loud 3 times each. Say them in sequence as if you are in the stop. Your body needs to know these as automatic responses so stress doesn't override them. Drill the sequence: order or request, lawful reason, comply under protest, no consent. Every time. Before your next traffic stop, there is more tactical intelligence you need to be field ready. The next video gives you counter moves for scenarios we didn't cover here. It's on screen. Watch it now while this training is fresh. Tell me in the comments, where in the world are you and what time is it there? This is tactical education only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. Know the tactics, own the encounter.